Hi guys, it's Kathy. I hope you're doing well. We made it to Friday. Payday for people. Even though it's already spent as soon as you get it. But it's still payday. We made it to the end of his closing statements yesterday. So we're gonna do her today. That's what she said. And when we do,
hey, perhaps this one shouldn't be on the list for the.
she's gonna stop in the middle of the word November. And then I'm gonna have to start the next one, and she'll say Vember when I start it. So we just remember she's gonna stop on the word November, and we'll be fine. We'll play a few seconds of him. Ugh. Don't worry about the camera. It's fidgety today.
Ms. Field? You are using the PowerPoint? Yes.
Yes.
Okay.
I think it is very easy for those of us that work within the judicial branch to immediately want to fix or find a solution to the things that come before us, right? You know, the cases, the controversies, and of course, you all's role as judges, your number one job is to decide the matters that come before you. You know, at its core, at its foundation, that is a judge's job, the number one job. And I've heard several questions from the panelists during the course of this proceeding about the fix here. What is the fix? And I can tell, and I appreciate that the panel wants to think outside of the box and to consider things that maybe it hasn't considered before, and to perhaps get creative in an attempt to fix the problem. But I would ask the panel to consider whether that is truly our role. And when I say our, I mean the commission. Because the Constitution provides that the JQC is the commission that has the power to discipline, remove, and cause involuntary retirement of judges as provided by this article. And so that's what we're supposed to be doing. And I understand Mr. Tate's argument that, oh, there's a provision in Rule 6 that says we can fashion, you know, other appropriate discipline. I understand that, but what the hearing panel would have to do in order to come up with some alternative sanction here is really to bend over backward in an attempt to fix a court that is not functioning efficiently. One of my primary concerns about us doing that is that every single judge in court in this state could come before this body and could come before the investigative panel and talk about being underfunded and understaffed. I myself, every year since I have been at this commission, have been part of requesting more money for more staffing for this commission.
Yeah, see?
I watch nearly every other agency in the state do the same thing every single year. And so again, I think that we have to be very careful wading into the waters of dissecting funding for courts and trying to figure out whether or not they're underfunded or they just need more money and it would be okay, and dissecting their staffing. Is 9 enough? Is 10 enough? Is 12 enough? If they just had one more, if they had a full-time associate judge, that would make it okay. I think that is incredibly risky for us to be doing as a commission. And if we set that precedent in this case, that that's the business that the hearing panel is in, then I guarantee in every other case that has similar issues that comes before this panel, you are going to be asked to do, and the expectation is, well, hopefully they will do the same thing for me. And again, while I understand much of what has been presented is appropriate in the form of mitigation in this circumstance, I think we are wading into dangerous territory with some of these considerations. Here's a timeline of some of the events that I think are important. Again, I know you all have heard that between the time that Judge Bordeaux took office in January of 2017 and now 2025, his staff has doubled. And so I don't think there's a dispute that the court,
Kelly, thank you for the cheers. Martha, thank you for the cheers. And Kelly, you are on a 7-stream streak. Ooh.
at nearly every opportunity has gone to the county commission and asked for additional funding so that they could fund additional staffing positions. And so that's not in dispute, but I think it's rather impressive that Judge Bordeaux during his tenure has managed to double the staff of the probate court in Chatham County. August of 2019 is when then Chief Clerk Wendy Williamson became also Associate Judge Williamson. And what's important about that is that she then became able to do additional things beyond what she was initially able to do as just a clerk. She implemented the Excel spreadsheet to track cases in 2021. I know y'all are tired of hearing about spreadsheet and list.
Thank you, Monica. I know the problem.
I just want to say this. The spreadsheet list that Judge Williamson started to do in 2021, and Mr. Lopez today read the email that went out to the staff with very clear instructions regarding how to access that spreadsheet. That is something that Judge Williamson did to try to help Judge Bordeaux. In 2021, that many years ago, she implemented that practice. And since that time, and you all will see, you have the records before you, the ones that I had to subpoena to get before you. But you will see that since that time, she and other staff members have repeatedly gone in, updated it, distributed it to him. They've done emails. They've dropped it off and by hand, taken it to him. The office next door, let me take this by hand to him. That's not something that he is entitled to. I bet every judge in this state, and there's a lot listening and watching this proceeding, by the way, would love to have somebody on their staff that put that amount of time, effort, and energy into trying to help them stay on track and get things done.
That is the whole purpose of every staff in courthouse, not a courthouse. The whole job is to keep the business running the best it possibly can. She created a spreadsheet, not even a great spreadsheet, because there was no rhyme or reason to how anything got on that list. It was just cases she put on the list, and some of them were already taken care of. And she missed the part where it said how old the case is. For real. Like, not what day did they file it in the courts. That's on there. That doesn't say how old the case is. So, yeah, she made a spreadsheet. Come on. That's what you're supposed to do.
Untimely, and that's what she was doing. She was trying to help him, and as a whole, she was trying to help that court run and stay on track and operate more efficiently. And so if there is an issue with, he made an issue with the tracking metric, months pending, well, there's disagreement with that, that's misleading. I also want to note that what is on that spreadsheet, Judge Bordeaux has not yet been charged with. And obviously, if charges were to come or an investigation were to come, the investigative panel would make its own determination about the time at which that trigger starts, essentially. And I told you all in my opening, we're not measuring from the time that the petitioner pleading has been filed. You all have heard this from me before. I'm measuring from the time that it became ripe for an order or a decision, right? Or a hearing should have been scheduled. That's something that we do, but I think as the panel considers that spreadsheet, it may be that not all the cases on there constitute violations of the Code of Judicial Conduct. But that is something that was done as a tool to assist. And again, I'm sure every judge out there would love to have somebody on their staff put that time and effort and energy into attempting to track things for them. You'll see some of those spreadsheets that are included in the exhibits that I gave today are multiple pages long. And you will also see that, even if, okay, we look at the months, well, 90 months pending, that is pending from the time that the petition is filed. If you look through the notes, it tells you the information that you need to know, right? For example, the first one on that spreadsheet, I think Mr. Lopez noted, the trigger in that one would be the date of the hearing, right? And Judge Bordeaux even agreed with that. So it was 2021 was when the hearing was. So if you're Judge Bordeaux looking at that spreadsheet, and he testified in August that he hadn't looked at it in several months, by the way. So even though it's there on that drive, even though it's been delivered to him, even though it's been emailed to him, he doesn't look at it. I think the evidence is pretty clear. He doesn't look at it, and he probably never has. But if he did, and he actually cared to dig into the cases that were on that list and look at them, he would see, okay, like this hearing was held in 21. You can do the math about how long that matter has been awaiting an order, and that is an egregious amount of time to be awaiting an order since 2021, right? And so, again, I did not enter that in an attempt to suggest that everything on that list was a violation of the Code of Judicial Conduct, but I do think the hearing panel needs to very seriously consider the fact that it was important to me to attempt to flesh out during the initial portion of this hearing whether or not the situation had actually gotten better, and whether or not he was caught up, if you will, on outstanding orders. And instead of just saying, listen, I don't really get that spreadsheet. I have some issues with it. Judge Williamson is the one who keeps it. Instead of saying all of those things and, you know what, I'll give it to you so you can look at it, we had to march down there and subpoena it, right? We have to go down there, subpoena it. We turn those records over to them. And then yesterday, I get the email that says, hey, here's the version he gave us the day after the hearing. So he went back to his office the day after this hearing and pulled that spreadsheet, and he's had it since then. I would also note, and I think it's important, they did a lot of questioning today about the cases that are on that spreadsheet, and kind of, attempting to, explain away why it's been pending this long, why something hasn't happened, and that's great. I think it is a little bit misplaced, especially in the circumstances where Judge Bordeaux, the day after our hearing, went and entered orders in some of those cases, right? I think that's telling. I think that's a judge that says, oh my gosh, she's asked about this, I refuse to give it, now she has it, these have been pending for too long, let me get these orders entered. And what I am asking you to find is that it should not take all of this. It just shouldn't take all of this. And I've got some commentary about their proposal that I'm going to save for the end. But the evidence shows that the first staff attorney started in November of 21. They got the new case management system in October of 2022. And again, we heard from Judge Bordeaux. Both of the case management systems that they've had have had problems. They're not sufficient. They don't work for him. The spreadsheet doesn't work for him. And I would also note that there's been a new staff attorney start, and so now there are 3 people acting in a judicial capacity on his staff that have been able to hear things, and that has been the case since September of 2024. I pulled a few excerpts from the transcripts of the first portion of the proceeding, and this is a question that I asked of Judge Williamson when she was on the stand, and I asked her whether her concerns about how long certain cases were awaiting orders or decisions, whether those concerns remained at the time she testified in August. She said it was a complicated answer because I think the reason that we've gotten those orders entered is because the JQC is involved, and I don't know what would happen if the JQC essentially what she was saying is if we weren't involved. And I think when you look at the record and you look at the timeline of events in these cases, the ones that are in the formal charges, you will see that this is in fact true. It took, in some of those cases, more than one letter from us, and in some of them it took until after we filed formal charges for those orders to be issued. So we're not talking just 1 letter, 2 letters, we're talking we have to file public formal charges in order for him to enter an order. And once again, I'm asking the hearing panel to find that it should not take all of that. The time and the resource and the energy that has already been put into the investigation and prosecution of Judge Bordeaux, are we going to set the example that that's what the investigative panel should have to do? And then the judge comes out of it with what I understand they're asking for is a reprimand. And I would ask the panel to find that no, that is not appropriate. Just to go through the first set of formal charges, and I would note again, Judge Bordeaux stipulated to nearly all of the factual allegations in both sets of formal charges, as well as almost all of the charges themselves, the violations of the Code of Judicial Conduct. But something that I think is important for the panel to consider is, and I know the panel has picked up on this a few times during the course of the hearing, but we came up with this chart to show you for the cases that were charged in the first set of formal charges, and that's in count 1 through 9 in that set of formal charges, the number of times that Judge Bordeaux was warned or put on notice that there was an order outstanding. And this is between letters from the investigative panel, inquiries from litigants and attorneys, and you all have some of those in evidence where attorneys were writing letters, and then these spreadsheets that Judge Williamson was providing to Judge Bordeaux, as well as in many of these circumstances, the letter that Judge Williamson wrote to Judge Bordeaux in September of 23 had some of these cases in it as well. And so I think it's important for the panel to consider the number of times, the number of reminders, warnings, notices, hey, there's an order outstanding. 16, 10, 16, 15, 3, 14, 4, 3, 5. I mean, there's not more. With those kind of warnings or notices, right, especially the one coming from, to a point that Mr. Hyde made, the one entity that can request that you be removed from office, right? Even that was insufficient. And so, again, I think it's important that for each of these, that is at least the number of times, at a minimum, that he was reminded that an order was needed. And so, again, what I've highlighted in yellow is in our view the kind of the trigger date or the date upon which an order would have become appropriate. He had the hearing in the summer of 2017. An order was not done until November.
She said Nov. Remember, she said Nov. That way you're not really confused right now. When she says Ember.
November of 2024. This was the very egregious one, 7 years and 4 months. And I would just note the things in red are the notices, the reminders. So we have Judge Williamson's letter, we have the IP notice to Judge Bordeaux, we have the subsequent notice from the IP requesting an order by June 3rd of 2024. We then have to file formal charges before he enters an order. And something I would ask the panel to carefully review as it's going through and drafting the report and recommendation in this case is Judge Bordeaux's responses to the investigative panel notices, and his second response, where the panel has now for the second time said, you know, you need to rule, we are requesting an order by June 3rd. He talks about the fact that he was busy with his election, right? And then just didn't enter an order. And then so he got charged, and that was the impetus for him entering that order. But again, Barnes was certainly the most egregious of these cases. Then we get to Maxwell. The motion I have highlighted there, and then the length of time that it took for Judge Bordeaux to enter an order on the motion to compel discovery. We have 4 years and 7 months in the Maxwell case. In the Adger case, we have the petition filed in 2020, and again, in red, we have the notices or reminders to Judge Bordeaux that an order was needed from him, so the letter, multiple IP notices, then we have the formal charges again. And so this is evidence that what Judge Williamson said was true, right? The JQC involvement is what prompted Judge Bordeaux to enter orders in these cases. It was not that things have suddenly gotten fixed at that court or suddenly improved, or it was the JQC involvement is what got the parties in these cases their decisions. Again, in Petty, we had the JQC multiple notices, formal charges, and in this one, we had 3 years and 8 months from the amended petition, 2 years and 8 months from the guardian ad litem filing a report with the court. That is the amount of time it took him to enter those orders. In the Deering matter, we have a hearing on the petition, an order on the petition 2 years later, and then it wasn't until September of 2019 where there was finally an order admitting the will to probate, and that was 2 years and 1 month. In Deering and Master Polis, that was 1 year and 11 months. And then again, we have the IP notice and the formal charges, the letter from Judge Williamson alerting him that an order is outstanding. And something I want to note, and Mr. Hyde has raised this issue throughout this proceeding, the statute related to Superior Court, State Court, and Municipal Courts regarding the time frame within the time frame for entering an order or making a decision on motions. The statute that Mr. Hyde referenced earlier, I think there's a really good question about the applicability of the statute requiring ruling in a certain amount of time to probate courts. We have not charged that here, but as the panel is thinking through that, if we're using that statute as a barometer and it's based on population size, it's either 30 days or 90 days. Let's go with the 90 days. And say that statute did apply to probate courts, and he had 90 days, unless the parties agreed in writing to extend it. None of these delays are close to 90 days, right? I think the shortest delay that we have here is a little bit shy of 1 year. So even if that statute were to be applicable, I think the panel should consider that we are not even close to the amount of time that statute allows for ruling or making a decision on certain motions. The May Jones case, we had 1 year and 2 months. The Crawford case, we had 1 year. The In re MD case, 11 months for the order on the petition for letters of conservatorship. And then 2 years and 11 months on the order permitting the voluntary dismissal of the petition to compromise a doubtful claim of a minor. Count 10 is the only count in the first set of formal charges that Judge Bordeaux did not admit, and it is a violation or an alleged violation of Rule 2.5A, and that rule requires judges to perform judicial duties competently and diligently, and so Count 10 charges him with violating that rule by not timely disposing of the matters outlined in Counts 1 through 9. My suggestion to the hearing panel is that if he has admitted Counts 1 through 9, it is difficult to understand how there is a view that he performed his judicial duties competently and diligently in reference to those cases. And so the director's position is that obviously the evidence supports a failure to perform the duties competently and diligently. I think it is easy.
But the rest of that is timely. How do you define timely?
The code doesn't define timely. So the view that I have taken, and you can see it in...
What did you say? What did you say, ma'am? The law doesn't say anything about time? Is that what you just said? There's nothing in the law about time?
In my charging decisions is when we are dealing in a court that is not bound or may not be bound by the provision that requires ruling within a certain number of days, we have typically looked to cases that have taken around a year or longer to get an order out or to take action to dispose of the case. And by the way, that's not in the Code of Judicial Conduct or anywhere else. I know you would know if it were, but that has been the position that I've taken.
Notwithstanding the size of the county.
And again, back to the point I made earlier, that is much more significant. That's much longer than the 90 days that Superior Court judges are given. All right, the second set of formal charges, there's a similar chart here for each of the cases contained in the second set of formal charges. If the panel were curious about how many notices or reminders Judge Bordeaux received related to those cases in the outstanding orders, whether it was letters from the commission, letters, inquiries from attorneys or the parties, or cases appearing on spreadsheets that were on the drive, emailed, or hand delivered to him, or in the letter from Judge Williamson, 19, 15, 7, 10, 10, 11, 8. And those are just in the exhibits that are there listed on that chart. The May Lyle matter, it took 1 year and 5 months. That's another one where the investigative panel gave notice and filed formal charges before there was an order entered. The Sackey matter, there were 2 different orders at issue there. One took 1 year and 5 months. The second took 2 years and 3 months. Again, the IP noticed on the Satney matter as well. In the Otis Young matter, the IP noticed on that one, it was 1 year and 7 months to get an order. In that case, Highsmith, 1 year and 5 months, the IP noticed on that one as well. Max Sr., 1 year, 1 month. Linton Parham, 1 year and 2 months. Once again, notice. IP notice on Bowling as well, and 9 months, which is a little bit less than a year. But that is the shortest one that is contained in the charges. Judge Bordeaux admitted to all those counts. He did not admit to count 8, which is just another failure to perform judicial duties competently and diligently. My view is if the panel finds by clear and convincing evidence that he either failed to perform them competently or perform them diligently, that is sufficient to find a violation of this rule. The panel doesn't necessarily have to find competence and diligence. My view is that competence or diligence would suffice as a finding. Here's another excerpt from the hearing testimony, and this is when I asked Judge Bordeaux initially about the cases that had outstanding orders that had not been entered, and his response initially was that he just wouldn't be surprised if there were cases out there with outstanding orders. And so something else I think is important for the panel's consideration is that Judge Bordeaux has had the tools and the things that he needs available to him in order to go in and check and keep track of the cases that need his action, right? Those things have been available to him. He chose not to use them, and I believe his testimony today was that he recognizes now that he did not prioritize properly. But I would ask the panel to consider when you are notified 5, 10, 15, over 15 times that, hey, this has been pending for a while, this needs your action over and over and over again, an excuse on the back end, oh, I just failed to prioritize properly. I don't know that really carries much weight, right? I mean, because the systems were in place. I mean, he was being notified. These things were being brought to his attention, and he was willingly choosing to ignore them and to do other things. And the representation that's been made is, we've got his badge in, badge out, records, and I think that's great, and those can be a good investigative tool. We are not disputing that he was at the courthouse on those days and times, but I've heard throughout the course of this proceeding, he's working all the time, he's working on the weekends, he's working. No, what those records show is that he was at the courthouse physically, he was located at the courthouse. The idea that he was at the courthouse working all those hours and we are still in this situation is a little dumbfounding to me. And his answer today about sanction was something along the lines of, if I am allowed to, or if I'm still going to be a judge, I'm just going to work. I'm going to continue to work. If according to him, he's already working 7 days a week, all hours of the day and night, how can the panel feel good about recommending a sanction short of removal when according to him, he's already working all the time. He cannot work anymore. There's no more work to be done. Judge Williamson is also working on the weekends. She's working a lot. And so I asked the panel to consider how can the panel be comfortable in recommending some sanction that, you know, is going to be monitored or be on JQC probation when he's working all the time. We fixed the case management systems. He's doubled his staffing. He has the people to do the job. All of those things are already in place, and some of them have been in place for years, and we are still here. And again, I know that the cases on the recent spreadsheet are not charged, but again, reviewing that information, I think it's clear, and Judge Bordeaux going back to his office and entering orders on those cases immediately when those cases had been on lists going to him for months, I think that's telling. And again, that is a judge who knows I better hurry up and enter an order on this case because it's been far too long. And that's why he did that. Here's another excerpt. This is, again, Judge Williamson's testimony. And she was asked, did he respond to you raising those concerns again in September of 23? And she explained to the panel, not really. He got angry with me. And she said that eventually he told her she had to leave. And when I asked what was the reason for telling you had to leave, because if I stayed, I would ride his butt. That's what the quote was. And that's what he doesn't like. I understand what he said today about their relationship, and he's, you know, they've kind of cast this they've created a picture of an office where the two of them are at odds and there's tension between them, and I'm sure there is. I think most people in the position of Judge Williamson, when you care about the operation of your court and you are constantly having to run behind your boss and remind them of these things and deal with the consequences of these kind of delays and this kind of backlog, you would be frustrated and there would be tension, especially if you had brought it to their attention as many times as she had. I think that's completely understandable. But I would ask the panel to review Judge Bordeaux's testimony about Judge Williamson from the first trial before she testified. There's even, at one point, he called her remarkable. He comments on how she's a great lawyer, how she is a great administrator for that court, and he's actually incredibly complimentary of her. And so if there is tension that exists in that office, it is because he has a subordinate that is frustrated with his inability to do his job. And I would submit to the panel that, yeah, that does create tension and frustration. All right. Underfunded, understaffed. This is Judge Bordeaux's testimony and his explanation for the delays. The proposed orders by attorneys are not up to par. He characterized himself as pretty picky. That was during his testimony during the first portion of this trial. He does not like virtual hearings. Today, when I brought that up again, he said he seldomly uses that. I would ask the panel again to consider, we've heard a lot about this little room that they have. It's insufficient, and it probably is. The way that it's been described, it probably is. He probably needs a bigger courtroom or more than one place to hold hearings. But we have two panelists that one's a former judge, one's a current judge, and who are probably very much familiar with the fact that utilizing virtual, the ability to hold certain proceedings, hearings, status conferences, whatever it is, virtually is a great time saver, right? You can get it done incredibly efficient. You don't have to have a courtroom to hold a proceeding or a hearing virtually, right? I mean, really, the judge could be anywhere. He does not like it. He just does not like it. He does not like to do it that way. I understand that virtual proceedings are imperfect, right? And sometimes there are issues and people logging on and they can't hear, whatever it is a great tool. And it is a tool that should be used by judges who are concerned about getting things done efficiently in their court and feel like they don't have the space to do it. That would be a great way, for example, for Judge Bordeaux to be using the physical courtroom. Judge Williamson could do something virtually. The pro tem judge could be doing something virtually. You can knock out multiple of those hearings in a day, and you don't have to have any additional physical space. does not often use the form orders. We heard all about that despite the fact that they're approved by the Supreme Court and the Council of Probate Court Judges. We talked about the list and the issues with Wendy's list, and I know it came out in testimony today, but Judge Bordeaux noted several issues with Wendy's list and the way that she was tracking things and things that she had in the notes section. And never once did he have a conversation with her or anyone else, to Mr. Lopez's point, about, hey, actually, this is the information, or here are the details that I would like plugged into that spreadsheet. Further, anybody that has ever used a shared Excel spreadsheet knows anybody that has access to it can go in and add their input to the spreadsheet. And so if Judge Bordeaux wanted to put into any of those cases on there, hey, a motion to recuse was filed on this date, and then the motion to recuse was denied by another judge on this date, he could have done that if he was communicating with the other people in his office. I would also ask the panel to consider that the obligation to supervise the staff and the operations of that court is his. And I understand that he has characterized Judge Williamson as the administrator and all this and that. The Code of Judicial Conduct imposes an obligation on Judge Bordeaux to properly supervise his staff. And so if the way that these cases were being tracked is not sufficient to him and is not good enough for him, that is his obligation, right? Regardless of the fact that there's tension or you're frustrated with Judge Williamson, whatever the reason is, as the boss, that is your job.
Isn't she subject to the same Code of Judicial Conduct then?
She is. But as the boss, as the chief judge of that court, the ultimate obligation is his. And I would submit to you, Mr. Hyde, that if you look through Judge Williamson's correspondence that I provided to the panel today, you can see the efforts that she made, and you review her testimony during the course of this proceeding. She really did a whole lot of things to improve the operations of that court, starting from the time that she first started. There were a lot of changes that came as a result of
But still, that's her job. That's her job. That's what she's supposed to do.
her, both in her clerk capacity and in her associate judge capacity.
He didn't deny that, but he said she was undermining it.
I heard what he said. And it doesn't surprise me that his view would be that she's undermining, but, you know, she, to your point, has an obligation according to the code, maybe more clear in the commentary than the actual rule, but she has an obligation to cooperate with this process. And so her involvement with this process, I would argue, is also an obligation according to the Code of Judicial Conduct. So she really didn't have much of a choice.
She didn't have much of a choice. She went into his office while he wasn't there and took pictures of everything. That's not her participating. That is her actively getting stuff against him.
Complaint by Mr. Tate in closing, and Judge Williamson was asked about this, that spreadsheet was only sent 3 times in 2025, and so it's insufficient, it's not good enough, it doesn't have the right metrics in it, but she only sent it to me 3 times in 2025, right? Like, it's talking out of both sides of the mouth.
No, it's not. Those are two completely different things and can both be true. And everything is resting on this stupid list. The judge did his own cases. The list was just a tool that he sometimes used. But it wasn't, she didn't create his schedule for him. She tried to create his schedule for him. Might have went better for him if she did create his schedule for him. But that's not what happened.
And again, that spreadsheet is not something that anybody is entitled to, and was simply a staff member and an associate judge trying to help in the operations of the court. Judge Bordeaux, throughout the entirety of this proceeding, has said something to the effect of, but he said this today, it is not valid or accurate that he is not doing his job. So we have very clear examples. He's admitted to the violations of the Code of Judicial Conduct that demonstrate he was not doing his job. And again, back to the thing that I said at the very beginning of my closing, as a judge, the judge's number one responsibility is to hear and decide cases, to decide disputes. That's it. Number one, the foundational job. and he is not doing it. And I think it's easy to stand here and say, well, these cases only make up 1% of the caseload. And we've heard that before, right? Look, it's such a small percentage of the caseload. Look at all these other cases. But in those cases, a delay of 7 years and 4 months, it's very easy to cast those aside as, oh, it's just this handful of things, and to not consider the people. And there were some of them that testified in this proceeding about the impact to them. And that is significant, to have something like that, these matters put on hold for years of your life, and to have to pay out and to wonder and not have any certainty, that is significant. And that is a failure of Judge Bordeaux to do the foundational piece of his job. The one thing, the primary thing that we need our judges to do. And he has demonstrated over and over and over again that he will not do it. He will not do it. And I would just, I know the panel is ready. In 2021, you have that information from the prior JQC complaint. And in that circumstance, I know that it's not exactly the same, but he was, in that complaint, there were issues related to timely disposition. It was the weapons carry licenses, so it was a different thing, but the county had to pay out. They were sued as a result of some of those and had to pay out. And so I would ask you, a judge in that situation, right, you get multiple mandamus petitions filed against you, and the county has to pay out as a result of it. The JQC was involved, and you come and you all have his response to that complaint as well. Mr. Monahan was in that complaint. He was included in Judge Bordeaux's response. Mr. Monahan drew this up, and I don't have the money and I don't have the staff that I need. That was in his response to the 2021 JQC complaint, right? And that was considered, and it ultimately got dismissed, right? It was COVID, and, you know, Judge Bordeaux was underfunded and understaffed, and you know, here's the data to support that, and here's an affidavit from Mr. Monahan. And again, the county has to pay out, but you would think for most judges that would be the thing that really wakes you up, right? You don't get here because that should have been enough. You know, I think this case would be different, and perhaps the panel might not be involved if this were a new judge, right? A newer judge, and there was no history with the commission. And by history with the commission, I mean the 2021 complaint, but also having to repeatedly send letters. Most jurists in this state know that when we get complaints related to judges failing to timely dispose of matters, even if it's more than one, oftentimes if we don't have a history of that, if it's never been addressed by the commission, we pick up the phone and call. We send an email and say, well, what's going on with these cases, right? And that is normally enough to solve the problem. So this case is unique in that most judges that start down this road or start to get behind fix it, and they address it, and they've never wound up here. Not with this many that have delays that are this significant.
What, if anything, do we make of the 61% of the vote he got after these charges were filed?
So only one set of the formal charges was actually filed at the time that he ran. It was set 1. Would set 2 have changed that election? I don't know the answer to that, but I can tell you set 2 was not filed until 2025. So for people who may not know the history of that court, they may have just seen that one set of charges and thought, okay, well, he got behind, you know, hopefully he'll catch up.
But you're asking us to overrule an election where he got an overwhelming amount of the vote, right?
So they voted him in office with only reading the allegations contained in the first set of formal charges.
I don't even know that they can read. I'm saying that he got 61% of the vote. What, if anything, are we to make of that? We're overruling the popular vote.
So you have been asked to do that before, and I believe it is appropriate in circumstances regardless of the vote. When the panel is in possession of information that they have a judge before them that continuously violates the ethical requirements that should govern their behavior, and there's no change. The panel has that information, right? The public did not have that information at the time they made that decision, and so Again, my position is that it is up to the panel to make the determination about what is appropriate based on the history of the judge before it and based on the violations that were before it, regardless of the votes that got that judge into office. A few notes on staffing. This excerpt is from Judge Williamson about having attorneys prepare proposed orders. She said, I don't think he was comfortable with that. And she talked about once when the first staff attorney, Amy Ehrig, drafted an order on a case that she actually sat through with Judge Bordeaux, and he did not utilize that drafted order. And then at the bottom of this piece of the transcript, you'll see there was another example she gave with the current staff attorney who had drafted an order on a motion for summary judgment, and the judge was not willing to sign it. And essentially, the judge has told me he's not going to sign something he didn't write. Another staffing point that I think is important, there was a temporary assistant that was paid for by the county. Her name was Deborah Ellis. She came in to assist after the former clerk that was arrested for doing improper things with funds left office, and Judge Williamson's testimony was that clerk was there to help us get Judge Bordeaux organized and get his system in place, and that was in 2018 and 2019. And then this excerpt, and I'm not going to read all the way through it, but again, it's just talking about the 21 employees that the court had or has at this time. It talks about the chief clerk, Ms. Poulos, and actually down at the very bottom, so starting at line 18, it talks about hiring Ms. Poulos. That was in 2020. She's the one that Judge Williamson testified about today, and in the first portion of the hearing, that started preparing the weekly calendars for hearings. And so once the weekly calendars for hearings were coming out, we would work from those to make sure orders were entered into each of the cases. The audit and monitoring solution, and that's what I am calling the proposal from the respondent. Mr. Monahan, Judge Bordeaux's friend, will do an audit. So that's piece one. And again, I touched about the fact that Mr. Monahan provided an affidavit for Judge Bordeaux. You'll see that in his response to the JQC complaint in 2021. But Mr. Monahan also testified that he assisted with some data and coming up with some information for Judge Bordeaux around the time that Judge Bordeaux took office. So now this is the third time that Mr. Monahan has been engaged or become involved, and he could have already, at any of these times, he could have already come up with the list, right? And so to the point that, not a list like the one Judge Williamson has done, we're going to get a real audit list from Judge Bordeaux's friend, Mr. Monahan. He could have done that. He testified that he had been willing to help. He testified about how close they were. And so again, there's been an opportunity to have this audit done and to have somebody who's a former county manager come in and dig in and look at this stuff. And one would think, facing the prospect of removal, that you would have just gone ahead and had that done. But again, Mr. Monahan's somebody that's been willing to help for years. And let's not forget, Mr. Monahan said that he called the county manager right before the first piece of this proceeding to ask for $10,000 to update CJT for Judge Bordeaux. And his explanation was, I understood that there's a way that software could, like when you log in, it can alert you that things need your attention. That's great that Judge Bordeaux has a friend that's willing to make that kind of phone call. That's wonderful for him. But I would submit to the panel that this is already happening. There is already the information out there that Judge Bordeaux needs in order to prioritize his work, in order to flag cases for him, flag orders for him, and he chooses not to take advantage of it. So this proposal, this idea, it's far too little too late, and it has been in place. It has been in place for years. The audit results will then be provided to Judge Bordeaux, and if there are issues, Judge Daugherty, a non-Article 6 probate court judge, will be consulted, and then Judge Daugherty is going to report to either me or the investigative panel, maybe the hearing panel, I'm not clear, but this proposal is rife with issues, right? So nobody should be the one making the determination about whether or not this case has had an order outstanding for too long, such that there's a code violation, or there has not
I
been
miss
action in this
Snoopy.
case for so long that there is a code violation. That determination is for the investigative panel to make. And just as I said about Judge Williamson's spreadsheet, if we proceed or decide to take action there, it's up to the investigative panel to make a determination about whether or not there's been a code violation, and for them to decide this is the point at which this matter was ripe for decision. And I would submit to the panel that that's not another judge's job. It's not anybody else's job, right? And the idea, essentially this proposal is asking other people in this situation, two other people who Mr. Monahan testified that he's more than willing to help, and that's great. Mr. Daugherty, and I want the record to be clear, I stipulated to the fact that he was willing to help, but I do not agree to this proposal in any way, in any form or fashion. And so I just, instead of Mr. Tate having to call him over for him to say, I'm willing to help Judge Bordeaux, I was willing to stipulate to that, and that's fine. But you have multiple people, I guess Mr. Daugherty would really kind of be the kind of field officer, probation officer, and then he's reporting then back to the investigative panel, who then is kind of what the probation officer that, I guess it would be me, then I'm taking the warrant to the IP to sign it. Like, we are not a probation or a compliance department. We're not. And I don't.
Then why is probation one of the sanctions we're authorized to recommend? How do we administer that?
It's not.
Well, we've done it.
Probation, I'm not familiar with that
But
term.
Mr. Tate's done it. How about that?
Okay. I can tell you that the investigative panel has done deferred discipline agreements, which is a sanction option under Rule 6. A deferred discipline agreement, again, is a confidential private agreement that it's done at the investigative panel level. And an arrangement like this, I can tell you, I've not done it since I've been here, but as far as assigning a sitting judge a mentor, yes, and having the mentor help them along, sure. Although most judges nowadays, when they are new judges, get assigned mentors. Judge Bordeaux had an assigned mentor, just like most other judges. So that's done. But deferred discipline agreements are typically done for newer judges when additional training or additional education would help whatever the issue is. And if the judge completes the additional training or the additional education and there are no other violations of the code during that time, generally the complaint is dismissed, but it's all done confidentially at the investigative panel level. I'm not aware of any disposition, certainly not a public disposition that was considered, quote, JQC probation, because again, I don't know how that, who would order it? Would it be the Supreme Court? Since the discipline in this matter, if you all recommend it, will ultimately be the court's order of discipline. So then, does the investigative panel send up a violation to the Supreme Court? Again, just thinking about the logistics of that, number one, I don't think it's appropriate for a case like this. But number two, logistically and
Damn,
just
Wendy.
the way we are structured and our rules are written, I don't see how anything like that works. I think an arrangement like that would be appropriate in the form of a deferred discipline agreement for a new judge with no JQC disciplinary history that had maybe a handful of delayed cases. This is the constitutional provision that Mr. Tate quoted earlier. And he quoted it in opening too. And he made me second guess myself because I know he knows JQC space, but the position that they have taken is because the conduct in this case is not willful, that somehow it's not conduct that Judge Bordeaux can be disciplined for is what I've taken from that. But the constitutional provision says that a judge can be removed, suspended, or otherwise disciplined for willful misconduct in office, which I believe the evidence supports here, or for willful and persistent failure to perform the duties of office, which I also believe the evidence supports here, or for conduct prejudicial to the administration of justice, which brings the judicial office into disrepute, which I also think the evidence supports here. So there are 3 different constitutional bases for discipline in this matter.
Does willful and persistent failure to perform duties of office require the same bad faith be proved as willful misconduct does? Do you know?
So I do not believe, or I have not seen a Georgia case that says that, but my view is that it would, based on the definition of what is required for willful misconduct in office that was set forth in Coomer and thereafter in Peterson. I would pull that same willful requirement or definition into the willful and persistent failure to perform the duties of office. Again, I've got the grounds up there that I believe the evidence shows qualify for discipline in this case. There are 3 that the panel can choose from. I would note that this same panel, in a recent unrelated matter, did find willful misconduct in office for a judge that failed to timely enter orders or dispose of matters. And that finding was based on the fact that the judge was notified by the investigative panel and did nothing, and then the investigative panel had to notify that judge again. And I believe the panel's finding was, at the time at which the judge ignored that notification and did not take any action and had to be notified again, it turned from negligence into willful misconduct. And so that is the argument.
Okay,
I
who
think the
is
facts
this
are
judge?
pretty similar here. That is the argument for willful misconduct.
But there's no
in office.
evidence that he's made false statements before this committee, though. And if you're talking about the last case, we found that that judge made false statements. I haven't heard any evidence that he has
Who
done
is the
that.
judge?
So I would agree that he has not made a false statement, but I do think the panel should consider an aggravation his unwillingness to provide information that I think was incredibly relevant for purposes of this proceeding. I don't, that is not cooperative, and I don't think that conduct is conduct becoming of a judicial officer. All right, those are the grounds for discipline. Mr. Tate actually quoted this commentary earlier from JQC Rule 6, and it talks about judicial misconduct of a lesser nature that does not require the judge's removal or suspension, either to protect the public or to preserve the integrity of the judiciary. And so I would ask the panel to consider whatever your sanction recommendation is, whether it actually serves to protect the public from waiting 7 years, 4 years, 2 years, 1 year on orders from Judge Bordeaux. And I think that you can look to his testimony. There were oftentimes, I think the first time I asked him, what was he going to do to ensure that this didn't happen again? He didn't have an answer. And I still, you know, I'm hearing today, he said, well, I'm going to work. I'm going to work. According to him, he works all the time. And so I don't know how the panel could really have much confidence that going forward, this situation is not going to repeat itself. And I do think the integrity of the judiciary has been very much harmed in this circumstance. So, but it talks about this, judicial misconduct of a lesser nature, and it talks about the facts indicating that a judge can continue to serve effectively with certain limitations. So limitations to a specific court or docket, or participation in therapy, counseling, or a recovery program. I don't believe that the evidence supports effective service as a jurist on Judge Bordeaux's behalf, and I don't believe that there are any training or education programs. I don't believe there's a mentor out there that can fix this situation, and in fact, the panel recommending a sanction that includes
Not in
somebody
Pennsylvania.
private coming in, doing an audit.
Anybody have any Jack in the Box near them? I've not been to one. Never. I don't know if I've ever even seen one. I've heard of them. I know what they are.
And then another judge acting as like the go-between between that judge and the JQC as far as reporting. Once again, I think we need to be mindful of the precedent that sets. If we're going to do that for Judge Bordeaux, if he gets to become the auditor after everything that has happened, the history of what has gotten us here, and all of the chances he has had to address this conduct before this point, if the panel then says, well, let's try an auditor and let's try, we can report if things get bad, the expectation is going to be that that's what every judge in a similar situation gets. They get a friend to come in and do an audit, and then they get a judge to, I'll help you if things get behind. I bet every judge in the state would like to have a friend out there that's willing to help them and be the go-between between them and the JQC. And so I think the panel has to consider the kind of precedent that it sets if it seriously considers that recommendation. Here are the discipline factors and the seriousness of the transgressions as far as delayed rulings, both the nature of the delay, which are extensive in this case, they're more extensive than the recent matter that was before the hearing panel, and the number of delayed ruling cases. They are serious violations of Rule 2.2, about as serious as those violations can get. The panel has to consider whether there is a pattern of the improper activity, and there is, and then the effect of the improper activity on others or on the judicial system. And that last factor I will end on, that is the purpose of the JQC, right? I understand that the function of the investigative panel and the hearing panel is different, but the JQC exists in order to enhance the public view of the system, and the public should be able to look at our courts and our judges and to be able to trust that if I file a matter or I need something handled or resolved in this court, I can file it there and have it handled or resolved. That's just a very, very basic expectation and something that should be delivered in all of the courts in the state. But, the effect on these people, and the panel only heard from a few of the people. If we put everybody up, we would have been in this proceeding for, a week and a half. And I know we don't want that, but I really ask the panel to very seriously consider the impact that these kind of delays have on the people involved in these matters, and not just the 1% that was argued to the panel as if it was insignificant, because it's not. So I will conclude with an opening. I said the recommendation was removal or a suspension, and so Judge Bordeaux and I do agree on the fact that I don't believe a suspension in this circumstance accomplishes much of anything, because the issue that we're here for is Judge Bordeaux not doing his job. And so suspending him from that office, and what I said in opening was an extended period of time, that takes him out of that office, even if it is without pay. He's not being paid, but presumably the county is going to have to bring somebody in, or some kind of assistance will have to flow to that court.
Doesn't the chief clerk become the judge by operation of law?
Well, I guess it depends on whether or not that office is considered vacated if he's suspended. And I think that's probably up to somebody much smarter than me to make that finding or that determination. But
What are you
certainly
talking about,
Susan
lady?
would-
You know
would
what's
be
gonna
there, and
happen.
I'm sure she would handle what she could. But I think the likely scenario or the reality would be the county paying to bring somebody in to assist for that period of time. And so we are recommending removal. Thank you.
Okay. You guys got any questions? No? All right, thank you.
I didn't want to object in the middle, but I do want to put one thing on the record.
Okay,
And there
go
was
ahead.
some allegation that what was brought in front of the investigative panel about the concealed carry permits, should be used in aggravation, and that's a violation of Rule 18 of the JQC rules. Any dismissed complaint cannot be used in aggravation, and I just wanted to put that on the record.
Okay, that's noted. Thank you.
I didn't want to interrupt.
Thank you all. Just a quick question before we close out from, I know we have the transcript from days 1 and 2 complete.
We do.
We do. I think Ms. Beal sent it out to everybody, I don't know, maybe a month ago, something like that?
Did
A few weeks ago?
Wendy help prepare that?
So we have days 1 and 2, obviously, and I don't know if the court reporter knows. Do you know sort of a time estimate of when we might expect the third and final day so that we kind of know that, because that starts our time clock, obviously?
I was given November 10th.
Okay. Okay.
What year? November 10th, what year?
Do we need it sooner than that?
No, I'm just trying to line up, so that we know, because obviously once we receive the transcript in total, that's considered filed and that starts the time clock for us. So I want to make sure that we've got our draft going so that we know. Okay. Well, thank you very much to everyone. Anything else we need to do before yes, ma'am.
I apologize for interrupting. Rule 18 that Mr. Tate just cited says that if a complaint has been dismissed due to insufficient evidence, the allegations made in that complaint shall not be used for any purpose. And so if you review that documentation that was submitted to the panel, there was no objection. It was not dismissed due to insufficient evidence. There was actually a finding, I believe, that the rules were violated, but that no discipline was warranted.
Okay.
What year was that?
We will look at that.
2021.
2021. Okay. Thank you.
Well, there we have it. We'll wait for a decision now. It's over. It's completely over. And now we have to know what happens. It'll be in the paper. It'll absolutely be in the newspaper. So thankfully, I don't have to pay for the decision for this one. We're talking December maybe. We'll see it in the paper. What he did was not right. But there's just no way they can, they'll publicly reprimand him. There's no way they're going to remove him from his seat. Only because the voters knew about it when they voted. It didn't come out after he voted. It came out before he voted. And they outstandingly voted for him. It wasn't just an easy, it wasn't just a tiny win. It wasn't 51%. It was over 60% of the vote. So this panel is not going to overturn that. They're just not. Wendy, however, this panel basically gave him the green light to fire her for insubordination. Like they said, I would have gotten rid of her. I would have gotten rid of her. So Wendy is gonna have a hard time coming up soon. She's gonna find herself not having a job soon. And then she did excellent work, maybe. I would never hire her. I just wouldn't hire her. And I'm sure other judges feel the same. When she went in there and took pictures of his stuff to give it to the board, that crossed the line. And no boss wants that. Why would you want someone to do that? Oh, well, if you're doing what you're supposed to do, it doesn't. Every person in here worked in their lives. Nobody does what they're supposed to do every day. We do what we have to do to make money. But we don't do what we're supposed to do every day. Projects, when I was at Millersville, projects were 7-10 years long, period. I would go a year or two without even touching a project, thinking about it. Were the projects important? Yes, they were. Absolutely, they were. And maybe getting those projects done would have, really been helpful, because most of them made things more efficient. But even serving tables, I don't do every single thing I should with every single table. And then who wants someone coming behind me taking pictures of that table and then bringing it in front of the world later? Look at this. She did not bust these plates for 7 minutes. These plates sat stacked at the end of this table for over 7 minutes. I have a video of her. She's out in the back alley. Where's Kathy? Where'd she go? Excuse me, do you know where my server is? Yep. Snitches get stitches. Yeah. But also, he knew he was going to get these charges. What the heck? Why didn't he get these done? I'll tell you why he didn't get these done, because he's the judge. He decides what happens in his court. Nobody else decides for him. Like the ego got to him. He'll get to it when he gets to it. He's the judge. And, no one bosses around a judge. But they're not above everyone else, actually. Because look, these 3 people up here who are way, way, way younger than him have his whole rest of his life in their hands. He's 82. So they're not going to be able to deal him a ton of damage here, no matter what they decide. If he needs to retire now, he's 82. He should have retired 20 years ago. He's fine. Should he retire? Probably. But who knows who's going to take his seat? If it's Wendy, underhanded. We got an underhanded judge in that seat now. And Wendy could start taking pictures of the lady, the black-haired lady. She's not a prosecutor. She's the special counsel, the director. She's going to start taking pictures of her next. That would be justice, wouldn't it? Alright, yep. Guys, thank you so much for coming out. I really appreciate it. We're going to get to OG now. And I shall talk to you all again soon. Just the dryer part did not work. And I took considerable effort on my part to replace that fuse. And it did not work. I tried everything. It did not work. So guess what I bought last night? A new motor. And guess what I'm going to do in 2 days? I'm going to install a motor in my dryer. I'm just bringing you all with me on this journey. We are going to replace a motor in a dryer, because if those guys can do it, we can do it too. I'll let you know how it goes. I have a couple broken ribs. Other than that, it'll be fine. Bye guys. Thank you.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for yourself.